So, guys, the battle for the soul of Rivers State is real ahead of 2027 presidential election. We case men have stormed the streets to protest ahead of the court ruling that we are waiting for. So, guys, it is now a battle between Wike and the judiciary. Is our judiciary going to bow to pressure, or are they going to give this ruling in a way to promote our democracy? That is the question. Just like we saw during the 2023 presidential election, the question remains, how credible is our judiciary in this case? Our judge is going to bow to pressure to favor Wike, or are they going to stick to what the law says? So, guys, talking about the 27 lawmakers who decamped from the PDP to the APC, and now they are looking for a way back to the party, I want you to take a look at what this lawyer has got to say about, their defection, the implication, and all what Nigerians are supposed to expect from the judiciary, if indeed our judiciary is going to stand strong and tall. Take a look at this.
Who has constitutional authority to govern Rivers State, regarding who are the members of the Rivers State House of Assembly, regarding who is supposed to exercise functions at the local government level. So all this was entirely and completely avoidable. But of course, ours is a country where politics basically thrives on individual interests, where the interest of the people, the electorate, in this case the people of Rivers State, has taken a secondary consideration, and that explains why we are in this position now. Am I ever very worried that we are now getting to a point where it is beginning to look as if there is a parallel government in Rivers State, as if there is a dichotomy on the question of who or what institutions have constitutional roles in Rivers State? Now, the Nigeria Police Force has a responsibility primarily to maintain law and order. And under the Constitution, specifically Section 215 of the Constitution, the state governor, the governor of Rivers State, in this case Mr. Fubara, has the power, indeed the constitutional authority, to give such lawful directives to the Commissioner of Police. And the Commissioner of Police is under a duty to obey and enforce it. However, the Constitution says that the Commissioner of Police may subject such directive to the Inspector General of Police, meaning that the IGP can override the directive of the governor. Now, we have seen reports, we have also seen evidence that the police seems to have taken over, access into local government secretariats of local government council in Rivers State. Is that really lawful? I think it is contestable, because I would have thought that, one, the immediate past local government chairman, the outgone chairman, whose tenure has elapsed by a fluxion of time, based on the doctrine of a fluxion of time, having subscribed to the oath of office upon their election, and I say election in quote, they subscribed also to their tenure, because the constitutional import, the constitutional significance of oath of office, is that when you subscribe to that oath, you subscribe to a definite term, right? So the tenure is also tied to the oath, and the oath elapses upon the expiration of the tenure at the time that that oath is subscribed to. And because this local government chairman subscribed to oath of office for 3-year tenure, their tenure having elapsed, I would have thought that they should have left office. But I know that there is a question before the court whether Parliament, whether the House of Assembly, and I say House of Assembly again in quote, could have extended the tenure of the local government chairman. I think that is an interesting question for students of constitutional law, because the Supreme Court has said unmistakably that the time set by the Constitution is like the Rock of Gibraltar. It is like Mount Zion that cannot be moved. And when you look at Section 7 of the Constitution, it says that a system of democratically elected local government council shall be guaranteed. Now, that system of democratically elected presupposes that the local government administration can only come into office, can only come into existence by election. And when you cast votes, when voters cast votes, what they are doing is, what they are basically saying is that we are electing you to serve in this office for a particular term. So if you are extending the tenure, you are also extending the votes. It is jurisprudentially impossible. I'm not passing judgment on the matter. I'm just expressing my view as an independent party. I'm saying that I think it will be a jurisprudential impossibility to extend tenure without extending votes. Because when people go out to vote and say, come and be my local government chairman, come and serve me as my local government councillor, you are saying, I want you to serve me for 3 years, in this case as in Rivers State, or 4 years in the case of president and governors. And once that tenure has elapsed, even the parliament cannot, even the governor cannot, indeed even the courts cannot extend tenure. I think this is not a question of dispute. I don't see any dispute here, but this is my opinion. It is left for the court to determine whether that is correct or not. I cannot make any judicial pronouncement. And what kind of country do we want? What is the essence of the constitutional provision against defection? Because the Supreme Court has said that Nigerians vote for political parties. And of course, now the law has a bit been modified to say candidates and parties. But you don't run for office without a political party.
As a sponsor.
That's what the Constitution says. I think Section 221. Yes. You have to be sponsored by a party. That is why you have the logo of a political party in every ballot paper. That's why when INEC is declaring the results, they announce the party along with the candidate. So when you leave the party, the Constitution says you withdraw your position. And we should begin to enforce that.
Inibehe, you are very right. There is no provision for independent candidacy in Nigeria's electoral laws.
On the issue of caretaker committees, as Fubara has been panel, undoubtedly that is also unconstitutional. The Supreme Court has made it abundantly clear that you cannot have caretaker committees at the local government. So this seems to be a case of dual illegal unconstitutionality. But whether the local government caretaker committees are lawful or not, of course they are unlawful. It does not extinguish, it does not abrogate, it does not derogate from the principle of effluxion of time that is applicable to the chairman whose tenure has expired.
Okay, Inibehe, good to see you again. Let's delve more into what's now becoming a sort of like a conflagration of some sort as regards what is happening in Rivers State. It really stemmed from these lawmakers. And there were some questions we asked a professor that was here yesterday about quorum in the assembly of Rivers State and the fate of lawmakers based on the constitution that have defected and left their party. I mean, what constitutes a defection in the first place? Let's hear your angle on this. And can 3 or 4 members form a quorum?
109. Yeah. Yes.
Go ahead.
Thank you, Rufai. Thank you, Rufai. Section 109 of the Constitution is clear that a person being a member of the House of Assembly shall cease to hold office. Subsection, this is in paragraph G. If he becomes a member of a political party other than the one on which he was elected. Right? So there is a question of defection. And it is a question of fact. Defection is a question of fact. It is not a question of law. Whether a person has defected or not is a question of fact. And I choose to believe the members who defected because I don't think they were lying. I don't think they were, putting up a movie script. I don't think they were acting a movie script. We saw it on national television. Arise TV reported it. The media carried it extensively. We heard it from them directly. They told us they had defected. They have not come back to tell Nigerians they have not defected anymore, or that they have even returned to the PDP. I also saw them. I'm saying what I saw. I'm not saying what I was told. I saw them carry the flag of the APC. I saw them sing the songs of the APC. I saw even the Rivers State Chairman of the APC associating with them, declaring them their members. So I don't know at what point the question of defection became controversial. To the best of my knowledge, they said they had defected, and I've said it is a question of fact. I believe them. If they were lying, they should tell Nigerians. Now, the question of quorum. The Constitution says 1/3 of the members shall constitute a House of Assembly. Now, a House of Assembly comprised of members who remains members at a material time, right? Meaning that membership of the House of Assembly may alter. It is not immutable. It is not immutable. It can be altered by circumstances that the Constitution itself recognizes. Namely, death. If a member dies, that will have effect on membership. 2, resignation. If a member resigns, that will have effect on resignation. 3, recall. If a member is recalled, that will also have effect on the membership. 4, defection. Defection. And the Supreme Court has made it clear in Abegunde and Speaker of the Ondo State Assembly. Once you have defected, you've lost your position. Right? All that is required is for the Speaker to have satisfactory evidence. But I did pose a question. What happens where the Speaker is one of the defectors? In that case, the House does not cease to exist. We must draw a distinction between the House of Assembly as an institution and individual members. The fact that vacancy has occurred, that vacancy has taken place on the basis of defection, on the basis of loss of membership, does not derogate from the existence of the House of Assembly as an institution. So the fact that these members have defected does not affect the existence of the Rivers State House of Assembly. So I had said that today the House of Assembly members are those that are in office, those whose tenure is subsisting, those who have not defected, those who have not passed on, because I understand one of them is deceased, those who have not been recalled, they are the members of the House of Assembly. So when you are answering the question of 1/3, my common sense tells me, and my understanding of the law tells me that you will determine that question based on membership existing at the time that question is put forward. So, pending when the court has taken a decision, those who have defected, who have not come back to tell Nigerians that they actually were playing, that they were doing a skit, we are to presume that the members are those who did not defect, are those who have not died, are those who have not been recalled. That is my interpretation of the situation.
Okay, Inibehe, 2 things. You are talking about Section 96 of the 1999 Constitution, which deals with quorum, right? But there's also Section 91,
yes,
which says you cannot have less than 24 members or more than 40 members, given the configuration of Nigeria at the moment. But I've had a lot of people, including Professor Wokocha, who came yesterday saying, look, Section 109, 1G, kicks into automatic effect. He's not the only one who has said so. That once you port to another political party, you have automatically vacated your seat. But these are the issues, some of the issues, that are before the court. I think, maybe lawyers should not jump the gun and wait for the court, to determine what the true position of the law is in this particular matter coming up again. Second thing, you talked about doctrine of necessity. But the local government chairman, that's with regard to the local government chairman, they are saying that the State House of Assembly amended the Rivers State Local Government Law 2024 and granted them a 6-month extension. The question that I have raised in this regard is that can the action of the State House of Assembly which is the Amehule faction, even if the legitimacy of that faction is part of the issue, can it be mutatis mutandis with section 135 sub 3 with the position of the president of Nigeria, which says that if there is war in which Nigeria is physically involved, then you can extend for 6 months. And then does it also relate to section 4, which says when there is a crisis in any house of assembly, the National Assembly can take over? Yesterday, Professor Wokocha dismissed my point and said there is no crisis in Rivers State or House of Assembly. In your view, looking at all these provisions, will you say that there is indeed a crisis? Will you say that the Amewule faction acted lawfully by extending the tenure of the 23 local government councils? These are the legal issues before us. Please advise us.
Well, let me start from the question of whether there is a constitutional basis for the intervention of the National Assembly, for the National Assembly to now exercise the legislative functions of the Rivers State House of Assembly in line with the Constitution. I would rather say that the current National Assembly should first demonstrate that it is even capable of self-governing, that it is even governing itself properly, that it is even carrying out its own legislative functions properly. I think it would be burdensome for the Akpabio Senate, for example, that is struggling to even define what its purpose is, whether it is actually an independent institution or an appendage of the president, to now be looking into what is happening in Rivers State. And I say that very seriously. I don't think this National Assembly has really exercised its functions as National Assembly. So when they have satisfactorily discharged their own functions, and have convinced Nigerians that they are a serious institution, if there is a crisis in a state, they can be caused to invite them to intervene. For now, I don't see any constitutional basis for that whatsoever. Now, the question of effluxion of time, the doctrine of effluxion of time that I mentioned, I must say that tenure of local government councils is not provided for in the Constitution. It is to be determined by law of the House of Assembly. That is correct. That is correct. But the Constitution, Dr. Bati, Section 7, says that the system of democratically elected local government council is guaranteed. And I explain what that means in simple terms. That you cannot say you are extending tenure without extending oath of office, without extending election, without extending the votes that were cast by the electorate. Because where do you draw the line? If you can extend for 6 months, you can extend for 20 years. That will be the implication. And I think that will be a grave constitutional anomaly. That will defeat the intent of the Constitution. And at what point do you extend the tenure? If you want to extend the tenure, it cannot be retroactive. It can only be prospective. Meaning that the Rivers State House of Assembly can decide to say, well, we no longer want to have a system of 3-year tenure. We want to have 4-year tenure for our local government system. But that will be futuristic. But you cannot say that those who have already subscribed to their oaths, those that the people of Rivers State presumably have voted for a definite term of 3 years, you will now sit in Parliament and say, no, I want to override the electoral will of the voters and extend their votes beyond 3 years. That will no longer be a system of democratically elected. Right? The local government administration has to be a product of election, not a product of legislation. I want to say that again. The local government system, chairmen and councillors, by the Constitution, they must be a product of an election, not a product of legislation. Legislation only provides the framework through which they come into office. But regarding how long they stay in office, regarding who stays in office, only the electorates can decide, except, of course, they are impeached. But once they are elected and they subscribe to the oath, that cannot be changed. Because if you change it for them, it means that The National Assembly today can amend the constitution and extend President Tinubu's tenure. Can even amend the constitution and change their own tenure. You cannot do that. And even if you are to do that, like we are having a discussion now, on a single term of 6 years for the president and governors, it can only be prospective. If the constitution is amended to change the tenure for president and governors, this can only affect future presidents. Tinubu cannot be a beneficiary of it on the basis of his last election. He cannot. It has to be prospective. This is my understanding of law. So for you to say that those who have already sworn to their oaths, right? Because if you are extending tenure, Dr. Bati, will you also administer fresh oaths to them? Will you administer fresh oaths? Because the oath elapses from the date they subscribe to it to the date prescribed by law on the date you subscribe to that oath. Simple. So this argument that, I'm not going to leave office, I am still the chairman and all that is unnecessary. But I leave that for the court to determine what should happen to them. But I'm telling my opinion as a lawyer and as a Nigerian, I don't think it is right. Regarding the question of the minimum number of lawmakers you can have in a state, I agree, right, that there is an irreducible minimum in the sense that there are constituencies, state constituencies, cognizable in Rivers State. But what happens, let us assume, this is just hypothetical, that members of the House of Assembly, not necessarily the present one, were to travel, and God forbid, an accident ensues, or a plane crashes, or a boat sinks, and they are all deceased. Only few are left. Will the House of Assembly cease to exist?
Maybe then you conduct elections.
That people in Rivers State choose to recall majority of the members. Will the House cease to exist?
No, maybe you conduct by-elections to fill the vacancies. There's provision for that in the law.
Exactly. But pending when you do that, does the House cease to exist? The House still is in existence.
So guys, it beats my imagination, when I see the way Wike is fighting for the PDP. So guys, it beats my imagination when I see the way Wike is fighting for the APC. Can you imagine you being a PDP member and you are working for the APC with all your life? So guys, we know that this battle has always been there. Since Wike said he was not going to support Atiku Abubakar of the PDP during the last election, but he will be in the PDP and he's going to support Tinubu. And even after the election, he said he's still a member of the PDP, but he's working for Tinubu. So one keeps wondering, what kind of nation are we building? What kind of political parties do we even have in Nigeria? Political parties without ideology, that are not firm in their stance. You can imagine one person belonging to two different parties and the leadership of the party is not even doing anything. It's not saying anything. They just allow Wike to do whatever he wants to do. No doubt the party is collapsing. So guys, Tinubu is desperate to take over anybody he knows can help him in 2027 presidential election. Don't forget that he understands that INEC and judiciary are his number one weapons. I mean, he already have those in his hand, but I tell you, Tinubu wants to take over Rivers State ahead of 2027, and that is why Wike is doing everything he's doing to make sure he destabilizes the state and his men impeach Fubara. And when Fubara is gone, they will bring their own person. And when their own person is there, the person will help them to deliver Rivers State to the APC, and then impunity will continue. So guys, that is why God is not going to allow Wike survive in this fight that he's fighting. Honestly, things must be done rightly in Nigeria. Let me know what you think about this in the comment section below. Please don't forget to subscribe to the channel, turn on the notification bell. Please give this video a like so that YouTube can recommend it to others. Drop your thoughts in the comment section below. Thank you.